see the real nitty-gritty of the complaint. And of course, the respondent's part says, we don't want to have to give you that, because then, your efficient arbitration process will disintegrate. And instead, we're going to have all these little mini trials, because we're going to want to see Mrs. Smith's allegations, and maybe have to bring Mrs. Smith in now, and maybe we get to hear the broker side of the story with respect to that customer complaint. And we really are going to have like a mini arbitration within an arbitration, because, of course, plaintiff's counsel wants to bring in all these prior complaints. And we say, no, that's not it at all. They're more than just allegations, because they're notice. Every case is a failure to supervise case. Someone should have been watching the broker. Someone should have been supervising that person's day-to-day activities. And if a broker has 1 complaint, 2 complaints, 3 complaints, 4 complaints, we argue that that provides notice, and management ought to be watching that broker a little more closely. So the existence of those customer complaints, true or false, actually go to notice. And you'll see in most cases it goes to a pattern of conduct. Rule 404 of evidence. These are prior bad acts. They're not admissible to show conduct in conformity therewith. Right. Rules of evidence don't apply to arbitration. Even if they did, we're going to be able to show it's a pattern of conduct, because this broker sold all his clients or her clients the same securities, irrespective of their underlying suitability. The evidence is a problem, because in some cases we had a case last week. I was trying a case last week against a major national firm, and the other side just kept asking his broker, after I cross-examined him for 2.5 days, the most leading objectionable questions known to mankind. Well, you fairly described all the risks associated with the securities, didn't you, Mr. Smith? The broker says, yes, of course I did. That was the leading question. So I objected. I said, excuse me, objection to the leading question. Counsel was suggesting the answer to the witness. And the panel said, this is a panel comprised of 2 lawyers and an industry person. The panel says, well, what do you mean? You would think that they're lawyers, they'd understand what the leading question was. Of course, I explained to us. No. You're suggesting the answer. He wants to ask what he said to the client, that's fine. He wanted to say what he described to the client, that's perfectly legit. But if you say, you told her all about the risks attendant with these securities, that's a leading question. But of course, the panel let it go on. I let it go on because I thought that I was going to have a strategic move, because later on I was going to ask the broker, well, gee, what were the risks you described? Because I knew full well he couldn't describe them. This person didn't have any understanding of any of the financial nuances. And it's interesting because most of these people that are brokers, I'm not saying all of them, but a fair percentage of the ones in the industry, if they went to college at all, they were history majors. When they graduate and they get a job in the brokerage industry, they think they're going to make a lot of money. They're given their Series 7 training or their Series 6 training, but with few exceptions, they're really not given any financial planning training. Most of them can't read financial statements. They certainly don't understand the variable annuities that they're selling to their clients, sometimes even an IRA accounts, which makes absolutely no sense. And they're given sales training. So after they pass their Series 7, they go to work for the big firm, and the firm says, well, hey, there's a new annuity or something. Here's all the bells and whistles that are associated with this product. They have sales meetings, but they don't have substantive training. They're required to get continuing education every year, and again, we'll hear about how they go to a seminar and learn about new products, but very, very rarely are they given any substantive training. Now, comparing once again the restrictions on substantive rights, the rules of evidence, you would like to think that the rules of evidence are just more than just a procedural right, because your ability to submit proofs, your ability to get in documentary evidence, your ability to even get the evidence you need in discovery are important. They determine sometimes the outcome of your case for substantive reasons, because you're able to put into brokers prior complaints. That's going to be important. If you're able to introduce into evidence prior cases, like in the Merrill Lynch cases, with the analyst reports, where it was shown that companies like Merrill Lynch and Morgan Stanley and Smith Barney, Citicorp, were making recommendations to their clients to buy particular securities, not on the basis of the merits of those securities, no, but because it enhanced the company's ability to get investment banking business, which was hundreds and hundreds and hundreds of millions of dollars. So it was shown in some of the Spitzer documents, when Elliot Spitzer, the former Attorney General of New York, won an action against Merrill Lynch, that Merrill Lynch had actual knowledge that this company was, quote unquote, a piece of crap. But they recommended it anyway, knowing that it was a piece of crap, because that's what the email said, piece of crap. Because they were trying to garner investment banking business from those clients, and had they downgraded the research report or give that person a sell rating because the company's underlying business was falling apart, they would have lost that company as an investment banking